please do keep in mind that these proceedings are being recorded and live cast. That first case is Shabeta versus Jackson.
Good morning, Your Honors. Jeremy Markman on behalf of the petitioners Joseph and Michelle Shabeta. And I'd like to reserve 5 minutes for rebuttal, please.
You got it.
Thank you, Your Honor. May it please the court, this petition for writ of certiorari helps reaffirm the precedential value of the right of privacy set forth in Article 1, Section 23, specifically with regard to the scope of a waiver of medical records in a personal injury action. The right of privacy has been reaffirmed by the Florida Supreme Court in this context in Waiver versus Meyers, which our position is precedential in this action. The fundamental right of privacy in medical records was reaffirmed, and the waiver of privacy interest when bringing a claim was limited and has been limited each time. The Florida Supreme Court in Waiver said even where there's a possibility that a person's extremely sensitive private medical information will be exposed, that is the type of governmental intrusion that the Florida Constitution protects against.
Jump right to the core of this, if I may. How do you reconcile, I know the value case, the VAIOU case, was just I think it was March 21, 2025 from the 6th District Court of Appeal. I think I cited to in these briefs. I think just distinguish that because I tell you what my concern is and I want you to be able to address it. You're absolutely correct when you said about the right of privacy. You're absolutely correct that the law supports that. But what troubles me here is that typically when people indicate either in their pleadings or their answers to their interrogatory specific items of injury, then it's limited to those areas. Here, what I'm concerned was that your pleadings were very broad, and in answers to the interrogatories specifically as to what body parts were injured, your responses see the medical records. So there's really nothing definitive about that. Sufficient. So for me, my concern is it seems to me that the case of value seems to be on point here, and I want to give you the opportunity to address something.
Sure, and I'd be happy to. I reconcile value the same way that the 5th DCA did after value came out in the Rodriguez case. Because value, the 6th DCA seemed to take the bull by the horns in this aspect when it talked about the Dominguez case, Dominguez versus Omana, in 2024, when it first addressed this issue. And what it did in that context was it had some dicta in there that seemed to turn the burden of whose burden it is to show relevance on its head. And what it did is, that's not what the 6th DCA did in Dominguez. What they said specifically in Dominguez was that where it was highly probable that irrelevant medical records would accompany the relevant medical records, the breadth of the subpoena was too wide, and it cast too wide a net. And therefore, they upheld they granted the petition of writ of certiorari in that Dominguez case. And then with a different panel, the 6th DCA in value in March of this year, then revisited Dominguez and turned that burden of whose burden it is in order to show relevance on its head. Traditionally and always, from the Florida rules of civil procedure right straight on with Florida Supreme Court precedent, it's always the requesting party who has the burden to show relevance. Instead of that, the 6th DCA said, yeah, I am now going to take that language from Dominguez about the way that they observed that it was highly probable when asking for 10 years of any and all records, that it's highly probable to have irrelevant medical records disclosed. And now it is the objecting party's burden to show that those records would be highly probably irrelevant.
And so, but even with that, if I may, and I know the facts in Dominguez and I know the facts in value, but here, your pleadings were very generalized. I would totally agree with you if you specifically said that your pleadings My client sustained specific, neck injuries, back injuries. None of your pleadings indicate that, not your argument. Select the neck injuries, but that's absent in your pleadings or any of the discovery. And so you're correct, but shouldn't you be more specific? Because you're basically generalizing, my clients got injured. And that's where I'm having difficulty with.
I understand, and so I'll address it this way, which is one, I think that the respondents in this case are acknowledging the limitations on the body parts at issue that we set forth, and therefore not particularly a decision for this court on this when they have acknowledged the limitations of those of neck, back, head, for both Joseph and Michelle.
Spinal cord too, right?
Yeah, spine, yes, spine injuries.
Which can radiate and affect pretty much the entirety of the human body, can't it?
Well, what I would tell you is that that's why in-camera inspections are so important.
Well, well, I'm glad that's a perfect segue into what I wanted to touch on. It also kind of dovetails with what Judge Gonzalez was just talking with you about. At this point, have we identified, or I should say, have you all identified any specific record that you are contending, no, this is beyond the pale, this is irrelevant?
The answer is yes, in that we have identified, well, I think I understand what your question is. Specific record? No, we have not produced a specific record or referenced a specific record.
Not quite my question.
Okay.
My question is, have you all reviewed these records and identified which ones you would contend are beyond the pale as irrelevant?
The answer is there's no record evidence that we have done that.
Because, let's just be candid. That hasn't happened.
Correct.
You all want to do that in front of the judge, essentially.
I think our first position was that clearly when there is irrelevant medical records that are going to be produced.
You haven't looked at it.
No, I think we do in that, say, for example, it's this case's decision in Zawistowski versus Gibson, right? In that case, same circumstance as this, nobody produced the medical records. The scope of the medical records in the subpoena in that case was limited from the time of the accident. It was the EMT records and the hospital records, and that was it. So it was from the date of the accident to the date of discharge. And so the time period and the scope of that was limited, but the body parts at issue or the relevant records at issue were only identified generally just like this, in that there was an issue about was the defendant drunk in that case.
Well, to be clear, what was identified were medical records from a list of providers that your client in turn had provided in response, I believe, to interrogatory responses as having provided healthcare treatment, correct?
Yet having provided healthcare treatment in the 10 years prior to, unrelated to, and not treatment related to this accident.
But again, how do you know if it's related or relevant until someone looks through? I mean, look, I get it. If there's some kind of, some kind of communicable disease diagnosis in one of the records, maybe it's there, maybe it's not, but somebody's got to actually look at it and say, yeah, that is beyond the pale, and we're not going to produce that. It seems to me what's really going on here is that no one wants to have to do that first pass through all of these records, because there's probably a lot of them, and you have to have somebody that knows what they're looking at review them without getting just an immediate determination. You want to do it in front of the judge on the first pass in an in-camera proceeding, rather than having to do the back and forth of, well, you all are this is too broad, this is irrelevant, we don't want to have to do any of this, just give us this in camera so we can just cut to the chase. Am I far off on that?
I think you are, and here's why.
Okay.
Because the practical aspect is, one, this is not just limited to the treaters related to this accident, but two is, if you look at the basics of medical care, any treatment records, and that's why Zawistowski, I think, in this context is so important, any medical records are going to almost necessarily have irrelevant information, because a doctor, when they go to medical school, does a history and a review of systems. And if you go to the doctor for a leg injury, the doctor is still going to say, what's your blood pressure like, and do the gastrointestinal issues, neurological issues. All that is unrelated to the leg issue that they treated for, but that necessarily means that those are private. So I think what's going on, other than it is not, we don't want to take a first pass at it. It is because the burden is on the requesting party, it is presumptive that there's irrelevant medical records in there, and now the requesting party has to show to the court why they're relevant.
By the lights of that argument, then, even the stuff that you would acknowledge was, the treating physician after the accident. I mean, I think you would, on the day of or immediately after, I think you would acknowledge that's probably within the bucket of relevance. By the lights of that argument, then, that still has to be subject to an in-camera inspection because there may be prior history that is irrelevant to the immediate injury, which means, in effect, as your friend on the other side points out, you want an in-camera inspection for every time there's a medical record subpoena.
Except that's not what we did in this case, and that's not what happens for practical purposes.
If we write an opinion, that's out there, and once it's out in the wild, it can go its own way because lawyers are very clever people. They'll make arguments based on the facts and the analysis that we provide in any opinion. So help me out. How would this be limited in a way that does not suggest what your friend suggests, which is that, yeah, you know what, pretty much every non-party production from a medical provider in regards to an injury case, there must be an in-camera inspection before anything is released to defense counsel.
Well, I'd say first, the 5th DCA reconciled that by not limiting it. In the Rodriguez case, which had the pleadings identical to these, the issues of spine injuries identical to these, and still said in-camera inspections are required even for the treating providers, even though in that case we also had no objection to it. But how does that work in practice is that lawyers will not be objecting to things that are clearly relevant. So, for example, in this case, what we've done, and the second option that we've provided to this court is what we argued to the trial court, which is go ahead and limit it in time and scope. A reasonable time period is 5 years before the accident, and a reasonable scope on the subject matter is the body parts at issue. And to address your question directly on the body parts at issue, it is not simply the interrogatory answers that define the scope of those body parts at issue in this case, because they also had an opportunity to review the medical records, which only identified those body parts at issue. And they also took the depositions of the plaintiffs, which identified those body parts at issue. So they were on notice and acknowledged what those body parts at issue is. And the opposite, Judge Lucas, the opposite of, how do we craft this in order to limit it, is if you don't craft it in order to uphold the right of privacy such that only the body parts at issue are in play, then every single case where there is a spine injury, there is necessarily going to be disclosure of private medical information. And as you talked about, that private medical information can be something completely unrelated to the treatment at issue. And that's why the Florida Constitution and the Florida Supreme Court and this court has repeatedly granted writs of cert in this context, limiting this time period and the subject matter at issue.
I just think it is a lot more of a fruitful discussion before our trial court colleagues if folks in that situation can identify, hey, we've got these kinds of records, these specific medical records and diagnoses, and that's irrelevant. And then the trial court can play the part of the umpire. They can do the in-camera inspection.
But understand what that would mean. In practical purposes, that would mean that if we've got medical records of a primary care provider that they're requesting that had no treatment for an accident, but they were treating them for an STD, that would mean that the plaintiff would have to disclose the fact that the person was treating for an STD in order to meet that burden of showing that there's highly probable irrelevant medical records.
A privileged log couldn't put that in a way that...
How would the privilege log look other than this is treatment that's unrelated without indicating what the private nature of those medical records are?
At least you know who the provider is, the date, and then you're talking, and how many pages it is. I mean, at least we're narrowing it down here. I just feel like this petition and the argument, we're talking about these inchoate documents that are out there with these people, and nobody knows what they are, why they're irrelevant, just that, well, we think that whatever they are, they're probably irrelevant because they might relate to some things other than what these injuries are about.
And part of our position is, Judge, part of the legal foundation of your perspective on that is that there seems to be a judgment on policy with regard to which types of medical information are more private than others. And the reason I say that is because the case law has said all private medical information has the same type of protection of the Florida Constitution. But what you're asking us to do is make a judgment call with regard to, oh, it's just a primary care physician who's going for an annual physical. If we put that in there, that isn't as highly private as something like ED or STDs or HIV, those types of issues. So that's why it has always been the requesting party's burden to show relevance. And when we're talking about relevance, we're not talking about a high standard that has to be met at the trial court level for the requesting party. I mean, tends to prove or disprove a material fact at issue or likely lead to discovery of admissible evidence. They haven't even done that in this case, nor is the court in the 6th DCA requiring them to do that because they turn that burden on its head. And the 5th...
We're at your 5 minutes, just as a heads up.
Thank you. And the 5th DCA specifically addressed the fact that the 6th DCA failed to follow the Waiver precedent. That's the way they termed it in the footnote in the Rodriguez case. Thank you, Your Honor.
Good morning, may it please the court. I'm Warren Quadnick on behalf of the respondents for the defendants at the lower court. A number of things to say. As far as the burden analysis goes, I disagree with the analysis that plaintiff's counsel is talking about. The cases that place the burden on the requesting party aren't cases like this. They're cases, and if you look at this, includes like this is a Kautsky case that has been mentioned. Those are cases where the records have been sought from the defendant in the civil lawsuit or from the defendant in a criminal action who has not put their medical condition at issue. Sometimes in a civil case, rarely, a defendant's medical condition is relevant to a very precise, narrow thing. Often the defendant isn't the one who put it at issue. For example, like in the case that starts with a Z that I can't really pronounce, there was an issue as to whether the defendant in that case was intoxicated, wasn't able to testify. So that made the defendant's medical condition at issue for a limited thing. In this case, we have a plaintiff who's broadly, based on their pleadings and interrogatory answers, has effectuated a broad waiver of their right of privacy. I think in this context, as the 6th DCA recognized, where they have done that and where they are in the best position to know what might exceed the scope of anything relevant, the burden should be on them to say that there's something should be carved out from the broad waiver of privacy that we've effectuated. That makes perfect sense in a case like this. And, Judge Lucas, I think, as you point out, they can do that. They can disclose it to the court in a way that doesn't actually divulge it. Your Honor is correct. We have, privilege laws exist. I think in a case like this, it would be, it's not sufficient to say everything that you've requested might be irrelevant, so the judge has to review all the medical records. There's a huge number of civil bodily injury cases throughout the state. That's unworkable and it's impossible. The plaintiff is in the best position to know. The judge in this case said, well, you've given me no guidance for in camera because you have pre-existing conditions alleged without any indication what they might be. You've had months. I mean, I think it was 4 months since the notice of intent issue subpoenas was issued. And they could have gone through records. It's probably voluminous and it's a lot of work. But that's what they should have done rather than dump that same huge quantity on the judge, say, you figure out what's relevant in here and let them know. The other problem with doing that is, and Judge Lucas, again, I think your words about the spinal injuries is largely mirrored in the concurring opinion of Judge Smith in the Value case, where he says, in that case also, it was a broad pleading and the plaintiff tried to limit it to neck and back. The court said, you can't do that. We're not going to let you deviate from your pleadings that way. But what the concurring opinion said is, by the very nature, both neck and back house the spinal cord, which indisputably connects to and impacts almost every portion of the body. Limiting medical records to neck or back in this context is not a reasonable or logical limit. So what's a judge going to do here? If he's to accept, notwithstanding their broad and undefined pleadings, if he's to accept, well, the plaintiffs are really just suing for, as they say, neck, back, head, shoulder, how is he going to determine what's relevant here? Especially when you look at the nature of the claims that they pled. They pled, among other things, mental anguish, loss of capacity for the enjoyment of life, chronic fatigue syndrome in the past would be relevant here. Because if the plaintiff is saying, I can't enjoy myself like I used to, Well, you've got to claim, how do we know what we were like before? A loss of consortium. There's any number of things. It's possible, I suppose, that something could be so completely removed that, objectively speaking, from the trial judge's standpoint, he can say, I'm not going to let you get that. But that would be incumbent upon them to say, Judge, there's a record from Dr. Jones between, in 2014, I think you can see that it has no conceivable connection, and let the judge do a 10, 15-minute in-camera inspection, as opposed to a week's job. And measure relevance against what? There's no pleading in this case, and there's no discovery in this case that we've seen limiting the body parts. I think it was mentioned that we know from the depositions that were taken. I'm not the trial counsel. I've not seen depositions. I don't know when they were taken. I don't know what was said. They're not in the appendix, and I think they're not before this court. They were not they were not mentioned to the judge, unless I'm mistaken. When this hearing,
They're certainly not a pleading.
they're certainly not pleading, and that's really the key point, because the case law tells us the relevance of discovery is determined based on the pleading. We really don't have to go beyond that. It's exacerbated by their interrogatory answers when we said, tell us what your injuries are, and they said they recapped the very same broad allegations, and then said, go see the records that were objected to, and then they said, and discovery is ongoing. So they left the door open to make it even broader, depending on what later discovery shows. There's no mechanism in this case, no authority that we've been cited to says that in this case, the judge has to review all the medical records when you have such an undefined pleading. I think the argument is that, and as far as Rodriguez goes, I think we were told the pleading in that case was the same. As I recall, the pleading is not referenced in Rodriguez. The other thing that's important about the Rodriguez case is it mentions that the plaintiff in that case did identify with some specificity the institutions that would have had the irrelevant records. I think in that case, it makes much more sense. It makes it much more workable. The value case is, in my mind, on point. The 6DCA got it right. A very reasonable decision. And again, Judge Smith's concurring, and you have also some very astute observations about this. Again, as far as the burden goes, I think counsel is taking cases that apply a very different setting, where a party didn't broadly put his own medical condition at issue and said the other side has the burden. I think it makes perfect sense, again, when they have made such a broad pleading that effectually it's a broad waiver of the right of privacy, the onus should be on them to carve out some portion of it that's not. I don't know if I mentioned this, but as far as the limitation, I probably did, but as far as the limitation of particular body parts, from my review of what led up to the order that's at issue here, understanding again that the pleading is what matters. I don't recall it ever being conveyed to the judge in any way, shape, or form that their claims are limited to particular body parts. So when we're here looking at a particular order and whether the judge departed from the essential requirements of the law in that order, I know their subsequent motion for reconsideration made some representation about the body parts. That argument, that motion was never addressed. I think it's still sitting up there. So when we're reviewing the order that's at issue, I believe that was the product of the judge never being told that the claims are limited to particular body parts. Again, I think the court understands my position, but I want to make sure I've covered any issue. So if there's no questions, I would ask the court deny the petition. Thank you.
Yeah, 5 minutes.
Thank you, Your Honors. First, with regard to whether or not it is the plaintiff's records or the defendant's records, we in the Florida Supreme Court has said that this same analysis applies in all litigation contexts. And this court in the Mueller case was a plaintiff's case with the same type of broad allegations. And the request for medical records was the military medical records of the plaintiff in that action, which included all of the same type of records that are requested here. And what this court said in Mueller versus Walmart was that clearly established law requires the segregation of irrelevant records, even when the temporal scope was restricted like it was in that case. There are numerous other cases, but when crafting a decision for Your Honors in this case, I think it's going to be difficult if you go with the respondent's position to reconcile cases like the Florida Supreme Court in Waiver or this court's cases in Tanner versus Hart Barker versus Barker, the Zawistowski case I referred to, the Mueller case I referred to, and Warren versus Morgan. All of those, other than the last one, are specifically with regard to medical records. Each of those requires a temporal scope limitation and a subject matter limitation. And in Tanner, particularly, they even talked about the fact that in that case, the trial court, like the trial court did in this case, required a confidentiality order or confidentiality agreement. And what they said, and what this court previously said in Tanner, was that that confidentiality order, which allowed disclosure to defense counsel and their experts, was also a violation of the constitutional right to privacy and disclosure. Even a limited disclosure to the defense counsel and their experts was still a violation of that right. And this court granted the petition of writ of cert in that case. So the other part of this is that the respondents' arguments that there's no evidence of, for example, chronic fatigue syndrome, but look how chronic fatigue syndrome could be relevant. That's the same speculative argument that this court is confronting me with, I think, when we're talking about shifting the burden. Because it's the requesting party's burden, they would have to show some evidence of prior chronic fatigue syndrome in order to show that the records are relevant. Otherwise, there is no evidentiary basis to show the records are relevant. And in this case, we did point out the medical providers that surely are going to have irrelevant medical records, including specifically the MCR. I mean, we're talking about the largest healthcare system locally with 48 locations, innumerable specialties. And so there's surely going to be irrelevant medical records in that. And I also point out to the court, I understand that this issue is difficult for the trial courts. And so does this court and others. In Tanner, in the footnote, this court said, we're not unmindful of the difficulty that such reviews pose for busy trial judges, particularly the implementation of the new rules and the budgetary constraints and such. We understand that this is a burden on the overworked trial judges. Nevertheless, what this court specifically said is, nevertheless, the protection of privacy interests is a significant constitutional issue. And despite the burden, it appears that the only way to protect a needless invasion of privacy is requiring an in-camera inspection. I'm not even asking you to go that far. So, Chief Judge Lucas, what I'm specifically saying in this case is you can craft an order that says if they haven't met their burden evidentiary by showing that there's likely relevant records in there, they don't get the records at all. And it's only those medical records where there might be relevant records and irrelevant records and no objection by the other side that would mean that the trial judge would have to do an in-camera inspection. And the reason we're proposing that is because that's what this court has held previously. And I think this court would have a tough time and would actually be required to overrule cases like Tanner, Zawistowski, Warren, and Mueller in order to do anything other than uphold the sacrosanct right of privacy and the limited scope of the waiver of that right of privacy in this context. Otherwise, there's a needless invasion of privacy. How the court's going to deal with Zawistowski when it was such a limited scope of just EMT records and hospital records right after an accident, and the issue was whether he was drunk or not. Clearly, in that case, there was potentially relevant records, is he drunk or not, and potentially irrelevant records, all the other stuff other than is he drunk or not.
And I figured you just have a minute left, Mr. Markman. I just want to make it clear. All those cases are correct. The issue with all those cases, they were specific in terms of what body parts were injured. The problem with your case here, as I see it, is that you never indicated in the pleadings as to which body part. It was very broad. And in the discovery, when they asked you to specify, you made reference to that. So I just want, when you indicate that we'll have to overrule all of these cases, we'll have to conflict. Those cases are right on point. But in this case, that was what was deficient in your pleadings here. And this is just my concern as to this.
And I understand your concern, but that's why we're taking the position. It is not the pleadings themselves that necessarily govern relevant medical records. That's why the burden is on the requesting party. It is discovery itself that governs whether or not something is relevant. And therefore, when it's the respondent's burden, they can discover what's relevant. If they think that there are medical records from MCR, from Michelle Shabeta, that are relevant to the action, they can go ahead and make a showing to the trial court as to why they're relevant based upon interrogatories. They could do a motion to compel better interrogatories if, like you, they believe that that answer was deficient. And if the trial court told us to, we would spell it out that way. And they could do the depositions, treating providers' depositions in order to narrow that scope. But what we've done is we've said, let's turn that burden on its head. It's now the objecting party who has to show that this is not related to a body part at issue, as opposed to the requesting party showing it's related to the body part. Thank you, and we'd ask you to grant the petition writ of cert.
Thank you both. Our next case is